On July 1st, higher education in the United States hits a financial brick wall. That is the date a new piece of legislation known as the One Big Beautiful Bill Act officially goes into effect. For years, graduate students relied on Grad PLUS loans to borrow up to the full cost of attendance at their university. If tuition went up, the government simply provided more money to cover the gap. This legislation terminates that system entirely. Instead of uncapped lending, Congress mandated a structural change. They divided all graduate degrees into two distinct tiers, locking each one behind a strict borrowing limit. Programs designated as professional degrees are granted a total borrowing cap of $200,000. The standard graduate tier faces a much harsher reality. Their limit halts at exactly half that amount, topping out at $100,000. As students' ability to afford their education now hinges entirely on the exact legal definition of which bucket their degree falls into. When Congress drafted the law, they successfully established the dollar amounts, but they left the exact definitions of what makes a degree professional instead of graduate highly ambiguous in the text. The responsibility to interpret those terms and write the specific operational rules fell to an executive agency, the Department of Education. At this stage of the process, unelected officials exercise significant discretion, defining the specific boundaries of the law by filling in the blank spaces left by Congress. Delegating this definitional power set the stage for a high-stakes legal conflict over who truly holds the authority to write the law. The Department of Education issued a rigid regulatory rule. They restricted the higher $200,000 professional category to just 11 specific fields, mostly traditional paths like medicine, law, and dentistry. They also added a stringent new requirement. To qualify for the professional tier, a program could not lead to a career where the graduate is supervised by another professional possessing more education or training. That supervision rule created an immediate crisis. It abruptly excluded vital, high-level healthcare pathways from the higher loan caps. Nurse practitioners, physical therapists, and physician assistants were financially kneecapped. Because these roles often operate under the supervision of specialized doctors, the agency dropped their borrowing power by $100,000. 8 major trade organizations, including the American Association of Nurse Practitioners, quickly filed a federal lawsuit to stop the agency's definitions. The plaintiffs argued this was terrible policy, but more importantly, they claimed it was a clear bureaucratic overreach that violated the original intent of the law. U.S. District Judge Beryl Howell took up the case, and issuing a preliminary injunction late Wednesday, pausing the restrictive definitions. Her ruling focused heavily on the constitutional limits of agency power. Executive agencies are authorized to execute the laws written by Congress. They are not allowed to invent restrictive new criteria. Judge Howell ruled that the supervision requirement was entirely missing from the original legislation. By adding it, the Department of Education illegally overstepped its discretionary bounds. The court's secondary justification focused on the immediate, tangible damage the policy would cause to the public. Implementing these definitions would create prohibitive financial barriers for students, driving them away from critical roles and worsening healthcare shortages in underserved communities. The court characterized the agency's definitions as an illegal rewrite of the law that placed bureaucratic preference over public welfare. The injunction forces the Education Department to back down. They are legally prohibited from enforcing their narrow 11-field definition. The agency must now evaluate programs based on the broader baseline criteria written directly into the law itself. But students still face a tough reality. While the court paused the restrictive definitions, it did not strike down the underlying loan caps. Congress passed those limits through legislation, meaning the $100,000 and $200,000 caps will still activate on July 1st as scheduled. A separate coalition of Democratic-led states has an active lawsuit pending to fight those top-line caps, but the current law remains in place. While bureaucracies wield significant power to enforce the rules, the judicial system remains the hard boundary, ensuring agencies enforce the laws on the books rather than writing new ones of their own.